Atta Akyea be grantee interview no. Atta Akyea say Samreboi case 6 weeks will be enough for me to prepare my written statement. As we sit here, Atta Akyea is going to go to court tomorrow and ask for 6 weeks, almost 2 months. That is 6 weeks. 1 month, 2 weeks. Ninyana say, or see obeko court or chirano ako plead with the judge and say, man is 6 weeks. Now on fan study case from day 1. Court omko day 1, day 2, day 3. All the documents that were shared in court, case management period, a year witness statement, or say judge na man is 6 weeks na on to me fan study nina reading nina. But remember, say a man is 6 weeks no already sign your way nina no ebibia. Written submission. After that, obey read actually, does it really matter here? Is it very important? Does it have any effect on the judgment? That is the question we need to ask. Say, am I attaching 6 weeks? The question is, so 6 weeks there, the man no. Oh yeah, what is the end game? The end game is obey written statement or written submission or written address, whatever. And that is his opinion. Now, at this point, does it really matter to the judgment? Does it really matter? Will it change anything? What did the judge now or case now about written addresses or submissions? Written addresses or submissions, does it really matter at this point? Now, before we continue with this 6 weeks, Wontumi Lawyer Atta Akyea, the strategy they are playing to delay the case, not for the case to even be judged this year, let's step back a little bit. Now, Mokai say case in the question BBC, and these are some of the abuses I'm about to show you. Make sure case in the question senior chairman Wontumi Atta Akyea could be abuse court for some reason the court actually did what? The court allowed it to go on. And I'm not saying the court allowed it to go on in a bad way. The court basically felt Chairman Wontumi needed all the time to make his case. But court now allowed that, what Chairman Wontumi Lawyer Atta Akyea did, and say they abused it. Omo making sure say sa chance na court dia mom no omo be say no omo de be gu court no hu fi omo de be kire say court no mumbu no. Now let's step back a little bit. This is a court proceedings. Me. Now proceedings we know, and this is what happened in court. It happened around the 3rd of June, all the way 3rd June. Satana case no koso. Now you see this document, it's public document, and media a court. You can go to court tomorrow, they'll give you all the documents. We can also publish this tomorrow. This is not Kevin Taylor's document, and this is a document anybody can have access to, a court document. Now on the 3rd of June, I send me see your court. That is how Chairman Wontumi and then the lawyer Akyea could be abuse the court, and so Atta Akyea wants to do that from tomorrow. Now that's 2 p.m. A date tonight, the 3rd of June, and so accused persons A1 presents and present A3. Sorry, present and represent A3. Now the counsel, Dr. Justice Samreboi, or the Deputy Attorney General, basically he was also the lawyer for Ghana. Let's make it simple. Now, so we study should you see a timer na case in the course and see how Akyea could be what he did in court. Any judge be only abutre, any court be they don't want to even listen to Chairman Wontumi anka Akyea could be that time ni nyina no anka ka ushebu pa nanke this case do this point. But all these things Chairman Wontumi and the lawyers, they never spoke about it. All the things they did against the court, all the deliberate action they took, no one say it was going to delay the case. The judge still had that had to accommodate. Omo ya nyoma could do point be judge bia say be one person be Chairman Wontumi ade timu odin person or ya quick no o judge asam no anka say be obegina sa adwoma ne su nyina ajudge asam no but judge ni nya abotre o wiase nyina ma Chairman Wontumi Emma Akyea could be any Chairman Wontumi mo disrespected court on several occasions, but the judge still believes say it was a Chairman Wontumi enya fair hearing. Fair trial is very important because he is just an accused or yet somebody who has done it so far as we speak. But so when you are now come back into court proceedings, now share idea appear could be deliberately on your court. Na judge na cause the bufu. Now I say no. This is too much disrespect. Eye de nimtiano doso. Just say oya lawyer penyin a wudi chema Wontumi enim but dia wo ye no I say we need the ho na opese ubu court enimtia na wudi di Ghana for the atem. But what happened was that judge did not do anything. And when I said did not do anything, the judge could have stopped the case there and said, hey, Muni Bibia, the way you are disrespecting the court, and I want to go ahead and write my judgment. But the court accommodated them. The judge sat and did not even react until at a point, Judge said, no. The abuse is too much. You see, to the point, after Judge said, this is becoming like a strategy of Apia Kubiniche Wontumi. And to the judge at a point, in court, the judge made it clear to them, said, no, the disrespect to the court, the disrespect to me, the disrespect to Obiano, deliberately, a counsel, and as a lawyer, deliberately changing things even in court. Case management, or to be back court, all of these things, Judge can say, what Shah would say, appear kubino or a lawyer be I just say on cano cre I just say delay case because in technical judge will be or bias now junior the cell person jelly chairman Wontumi and case in can do her but this judge feels to say chairman Wontumi needs to be heard, chairman Wontumi the witnesses are supposed to come, chairman Wontumi whatever is provided we need to, but it got to a point you could see say chairman Wontumi appear kubi they were deliberate in their actions. They wanted to abuse the court per se almost say case I'm doing this and I say that is the same 442 formation and at the attaching Akyea free. They just want to delay the court. They don't want the judgment to happen. Into attaching also called court or 6 weeks. On from study documents. Abra case near Kenwe. Now my mention you see court and why attaching to me respectfully to the court without the respect to the judge. I believe attaching is not even supposed to be heard tomorrow. That is what I believe, myself and my team. I believe, say, the disrespect from Chairman Wontumi Council 1, Council 2, it is too much. And the same strategy, the same thing I did attach Champersoye. And I believe, say, the court is not supposed to tolerate this. Not had there. You see, when you read on the 3rd June proceedings, you ask yourself, say, but why was the court allowing this? Now, Mami Ridi Adewincho, this is what happened in court on the 3rd of June. Oh, sorry. On the 5th, right? Yeah. So, on the 3rd of June, Omoko court I did see any. So, on the 3rd, almost on the 5th. But the judge had to address Adibia, Apia Kubini Chairman Wontumi Ababe Attachia is doing same, and that is the most dangerous part in this case. Now, Hadia, let's take our time and go through what actually happened in court. And these are some of the things that Attachia is asking for. And these are things that are documents that he can even go to Apia Kubi and demand. But because he wants to delay the court, he wants to abuse the court, that's why they are doing this. But I'm sure before Ochina Omako court. Now, on the 5th of May 2026, this is 5th May, near June crowd. Now, they see a court. The accused person filed 2 witness statements out of the 5 witnesses they listed. Now, on the 6th May 2026, the accused person filed another witness statement, making 3 in number. They, however, informed the court of their intentions of filing 2 witness statements in addition. The court conducted CMC on the 3 witness statements and proceeded with the trial with the anticipation that the 2 witnesses, the other 2 witness statements will be filed by the accused person before the end of cross-examination of the other 3 witnesses. So, I'm file witness cases, witnesses say Sanipa we and your court case management, your person omoba. So on the 6th, the accused person filed another witness statement. Remember, on the 5th, the accused person filed 2 witness statements. Now, out of the 5 witnesses they listed, inti now or say or nipa or witness statement 5 Sibu wa file. Now, what happened is on the 6th, even though on the 5th, no, I say 5, no, on the 6th, no, a buy, no, I feel or say they can only file only 2. But during the CMC, that's the case management, they said they were going to file 5. Omobedru court on the 6th, almost they are going to use only 2. Now means 3 now also file famba. That's fine. The court allowed them, and then you can see it was a deliberate thing they were doing. Oh, yeah, the nipa 5 remember. Omuni ebe from our bad kim abeka omanu asem ne atoto omano no maboa me with chema Wontumi. Afi om kodru court pe na dani. Oh, yeah, the mienu pe na beba nde. Abra bodin kan aye case management. Judge atia say oh nipa num na bia and ombeba nipa num na ya file ya be free we and ochane afre we no. What they do they say omokoye sa meeting we no mudru court pe na apia kubi we change bibia instead of 5 statements both adani 2 and adani 3. And this is what transpired on the 5th on the 6th of May. Now don't worry, young queen there. However, at the end of the cross-examination of the 3 witnesses, the accused person had not filed any additional witness statement. Go ahead still, and then they did what? They cross-examined the 3 witnesses from Chairman Wontumi. Now the funny thing is, time cross-examining of the 3 witnesses, the accused Apia Kubi, they have still not filed witness statements of the other witnesses. Now, the court cautioned the accused persons and gave them 7 days to file additional witness statements if they are so minded. Inti ema court bufuye, judge ni bufuye. Eno ka say Apia Kubi. Sa ankofo ya wo say omo ba be witnesses amache ma Wontumi. Me ame ba be won omo say omo empe omo asem a omo mbra no me file omo state because on paper the CMC case management actually say e also mbe file na yetumi ko enimo case no. Inti ma judge bufu ye court. Eno ka say de mo ye no nyanse bi enim. Ye ko case ni nyina ho adwuma behind the scenes say nipa dodo say na ebe kasa we na beto ye beduru pe na wo Apia Kubi ni Chairman Wontumi enkofo also mbe kasa no na sebio ye hu bebi omnam omo statement so omo famba. How are we moving forward? And all this the judge had the patience to listen. So at the point the judge said no, I need to send a caution to Oma Jatum so mbe witnesses for Chairman Wontumi. Now, this is what happened on the 25th of May. So from the 6th, the 25th of May, something happened. On the 25th of May, 2026, the accused persons filed a 4th witness statement in the name of Honorable Kobna Ochredaku Mensah. The court conducted CMC on this witness statement and proceeded and adopted the evidence in chief of the witness. Cross-examination commenced. The mouth of the witness was sealed and matter adjourned for continuation of cross-examination. Right now, witnesses mienu Chairman Wontumi Apia Kubi be file. So judge ni ma sa caution no. A mu say judge ni bu fuba no. Eno de ba ko ba so ye de ba ko aba. Na ba ko na Kobi Ochredaku, the former Western Regional minister. Akwana de nise petu no. Jimmy no numwi no. So when the guy came to court they see and they say Apia Kubi mo making sure say won kasa. Cross examination ye beto to witness na no. Apia Kubi ene Chairman Wontumi ba no. Almost so effort strategy be say witness no eni say obi na no kasa almost silina no almost person obe answer to anything. And that day no ye ntumi ndi dwuma bia or court. And a court case, you know something, let's adjourn ye two case ni sheda. They use another technicality to prevent the witness from speaking. When they were in court that day, Saturday ni so no awosanka Kobi Ochredaku Attorney General in Samano ono so to obudin yebusana ono so person bekasa Emma waste time Emma Apia Kubi use delay tactics for court say because of something me client into me kasa because of Emma akwano sorry kofi ma yentumi antena case so Emma judge ni sa to case ni sheda because the time not time na court. And remember from the 5th of May judge need to make nyadian abutre for all these things. From the 5th of May to the 25th of May, anka witnesses ni nyina anka cross-examine but Apia Kubi deliberately or making sure say court no schedule no schedule no because he wanted to delay the case. He never wanted the case to end. And these are some of the things they did in court and the ABPH attaching so picky from here. So I had to say a baton. We eko kakra no da koma we now we have delay. So it's a delay strategy. Now the same court, my sure the course is here. They see any before continuation of cross-examination, counsel for the accused, that is Atta Akyea, person informed the court that, let me take this way, before continuation of cross-examination, counsel for the accused person informed the court they had filed a supplementary witness statement in respect of the same witness. In terms of our court, I feel that Atta Akyea catch the court to say, "Eye kobi ochedako." Or the statement I had tuma yebe busa na no asem no. Atta Akyea say was file another statement akasa statement no home. Until say yebe sa statement na tumu no. Sa eye kobi ochedako no tumi nkasa. But remember, answer na witness babet na dakem ni busa na no nsem no. Ye frɛ bi CMC. Judge no on it 2 lawyers no ehia behind the scenes. No mu nyina je eye questions ebe busa nipa no atum ye wi a na ye de ama eye court no eno na ye dru court ebe di hu nkomo. Now what Atta Akyea did and say statement na eye kobi ochedako edin kan attended in say eno na eye the witness statement attorney general ebe hwe so to na no ade chi bi no betena court a Atta Akyea catch the court say ne witness no esa wa another statement bi a or person de saka the statement no, meaning sa first statement na da ho no yentumi ndi ho adwuma yensan kɔ biem na yenkoya another CMC case management behind the scenes na yen first supplementary statement ne san kan the witness statement no, meaning it's a clear strategy to delay the court. And all this while na judge no won't show any anger. The judge was still accommodating Atta Akyea. Kobi Ochedako first time almost Selina no mama nankasa Atta Akyea make excuses. Ade chibero metenasia Atta Akyea catch record say oh me witness no one send be can you rempo afinti esa de beka ho na eno no because court engine to munti they are not going to allow a cross examination omo pese court ne gin supplementary edien na asam ne saka ho ansa na yato aso, meaning the delay tactics is in force. They just don't want the case to move forward. Make sure the delay of my bedroom there, or my abuse court now, and the court should not allow Atta Akyea to even make a statement in court. The judge or the court should not even entertain Atta Akyea because Adia Atta Akyea from day one basin, that is what Atta Akyea is continuing, and it's also up 6 weeks, and when you give him 6 weeks, you ask for another 10 weeks. Now, my material abuses nibi. Now, so when this happened, now the judge started getting frustrated. The judge started getting angry because it looks like say the taxpayers' money no say sanko for person say no. Every single minute we are judge we are basically paying the judge. Every minute we are general court we are basically paying them. So the judge is like, you know what, the taxpayer, we cannot waste their money like that. We need to basically move on, do the thing. I said, "Debiano, I appear to be chairman. Want to be bar witness, cra. Witness about na document. Ya printed document. Obianum so we dey busa question. Or say witness so akai bibi. Inti esi ano yen to be kasande. Yen fan ko kan answer na witness na kasa. Now the judge went something happened. Now, notwithstanding his so this is what happened. Notwithstanding this irregularity, the courts obliged and conducted CMC on the supplementary witness statement and proceeded with the trial. Inti Atta Akyea be ba enom so yes sir statement bi a eye Kobi Ochedako asa kan anadwi inti pese de kan and court said no problem. Se mo pese supplementary e mo de kan ho a court tena court mo gitu no so mo san fan kan ho. Because we cannot make this thing delay the case. Yet to me, must have supplementary statement we end delay case. Until the judge was patient, and the judge said, you know what, we whatever you want to do, we will accommodate you. So the judge accommodated the Atta Akyea guy again, and also and the judge allowed that to happen. 3 times these people have abused the court. The judge did not say anything. The judge wanted the case to flow. The judge did not want to be seen as biased. Judge Bia said, he or she would not even entertain this nonsense. He would just move or she would just move. But this judge took her time or his time to be taking all this nonsense from Atta Akyea and the Wontumi. Now, make sure they see it. Now, the judge decided to speak. After all these things, now the judge decided to speak because now I feel it too much. Oh, who is at some to me 1 week I cannot. Now we are spending 3 weeks or a month on it. Witness a bit to me across examining in a day. No, we are spending 2 weeks on one witness. So the judge started getting frustrated. Said no, I didn't know and I say more abuse court. And I say, much rather than person would say, delay Ghana. So the judge says something. I'll say, I have painstakingly gone through the trajectory and conduct of case management conference in this trial, mainly because my attention has been drawn to a witness statement filed on the 28th of May 2026 in the name of Honorable Evans Adai, who intends to give evidence for and on behalf of A1 and A3. Also, when you would say at Akenkan Case Management Conference, that is CMC meeting on behind the scenes and Sani Abakota Bekasano, I will be adding document bachelor judge. So when you be someone no. Also, when you would say a study ako back ako check a case management conference or no accused any the prosecution not say and when we say one witness a friend or a Honorable Evans Adai or no na eba bema de evidence obema obe yebeto no emana de evidence aba be defend chairman Wontumi and the third witness no or say the name on this witness statement is not one of the names listed in the list of names of witness filed by the accused person. Judge says, but enda yeba court no. Yenim said there are 5 accused people. The 5 witnesses are omo babe den yeba be cross examine omo. In fact 3 ya cross examine omo wi aka 2. But osi yeba court no. Afemi hwen krated ma papa your friend de Evans Adai no. Ni dinim. He is one of the people so I also who accused a lawyer and I say who Atta Akyea. You need to make sure he is available. Why say what sabete say dipa we ba be kasa amache ba Wontumi but you be do court in no sa edine what is going on judge say na Atta Akyea di adwuma na wo ye ne sa no because nipa o say obeba betena say me atoto na no ama be protect a defend chairman Wontumi no list ma hwemu nyina menya botra ko CMC, that is the case management conference mako study names I will list the breye say eno sankofo we na wo be from e de o ma betena da kem ema omo sebe yatoto ma no a omo defend chairman Wontumi ba me court ya no sa brantie ni dinim die enti na wo yesa. The judge started getting furious. Because now it say Atta Akyea any chairman Wontumi no omo adwene say omo person abuse omo go court na nimfi omo person case ni because so omo dada court no. And this is something that happens so many times and one day this is something Atta Akyea any chairman Wontumi yeah they never spoke about it. The judge did not speak about it. Even the prosecution and the AG never came out to say this is what Atta Akyea is doing in court. There was never a day the Attorney General came out to have a press conference to tell us to say Atta Akyea mo to the list but say witnesses way bekasa near year from na judge we never heard the Attorney General make this statement in public. All along the Attorney General was also focused. The Attorney General allowed the court to deal with these things, but say Attorney General be or public sympathy or say I'm for merchants or anchor this will be his talking point. And this will be his defense. He will be all over the place saying the reason why the case is not done is because Atta Akyea say the court document is they go and check court proceedings. But the Attorney General did not do anything because the Attorney General at that point, his focus was to get witnesses to cross-examine, to get the truth out of witnesses. It will say I feel the judge no ya main judge no technically the all can say Atta Akyea twa court ntro Atta Akyea deliberate na da ho na o twa court ntro on person be de no o person delay case no na yanko enim. The name on this witness statement is not one of the names listed in the list of names of witnesses filed by the accused person. It is not for nothing that the practice direction on case management provided those direction to be taken or see enyekwa say yeah case management conference. The reason yeah case management conference and then say send your beya Attorney General per se or the prosecution witness ba wo Atta Akyea ubehu nipa kro ubehu omudin ubehu nipa dodo send beya wo so Atta Akyea what the prosecution accused witness ba yes ubehu nipa kro ni din o say enye sa kekenti na CMC butai bi tare chire na se wo beba court na ya meet na wie na betena court na de adefo fraba means se wo no court no person be court no. It's not judge no to Atta Akyea for say they all no or say case no nani da ho no o book court nanim tia. He is disrespecting the court like deliberately. Now already document where a court document you can go and ask, they will give it to you and media. Now say obesa will follow proceedings say see court after this no something happened. The same court but me ready they see in chiro me ka ba be see the Attackea no so the same strategy Apia could be taking and no be no taking the disrespecting of the court, abusing of the court. Say court more opportunity to pay, they'll blow it up. MPP lawyers way Apia Kubi ana Attackea way 2 days obe say no man could do 2 months. That is why we have to be careful, because court, you don't allow these things to happen. The moment we give room for that, other criminals, their lawyers or their counsels, that will be what that is what they will be doing. Ochina omoko court into you menya abota medwudwa we mu akiro. Now when you move ahead, this is what it says. The bedrock, I wanted to read this is the latter part of the second one. Change in circumstances to cause a witness to be changed, substituted, and added. It is for the accused person to seek leave of the court, giving reasons for same, and not the situation this court is confronted with presently. Judge Nika say we are accused lawyer. Apia Kubi. Now so person was a witness. And now say witness be changing the D and now we the D from and now obi fufuro be shema. You have to follow the right procedure. Unim send ye no court ya. But what Apia Kubi eye say obeka say Kevin Taylor na ebetena adakem ade abechi ye beba no na Kwame Amoako ye busa na or see when the agenda case in the uncommon Kevin Taylor. Inti Judge Nikachen said that thing now Apia could be no good court in the oh disrespect the court no. In fact, court any chance or the amount say the lawyer for Chama Wontumi not to me a protect and I said defender no. It is looking like say what is our opportunity no, what the abuses our opportunity no. It's Judge Nika point to explain to him say yeah sa. Adia wo yen enye wo na wo ma case ni delay because we are not supposed to do these things. What the witnesses list bar also making sure so we so but to me court now witness list no ebi ayira obi din nim enti na judge na kire say ye adwuma say court mran wo ho unim dada so obese say obi krampa there is a way you do it, there's a way you go by it, but you just don't appear in court and say me change way without any formal approach to it or formal a way to approach it. It's not judge say no what is going on no o say case no o disrespect the court no o abuse the court no. Now, Mumiankoso and Yanko who see your court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti Judge ne say, "Hey, apia ku bi ni chema Wontumi nti ase. Nyoma ma ebebrea mama mo chance a sebio mu bu court ne abomfia mo disrespect court no mu delay case no o say saa nyoma na media mama say muntumi emfa nka mo asem no enkyere say mu betumi ebu court ne mfia ana abomfia mu betuma disrespect court no o say de mi wi kyere say saa na mo pesa mo ye o say yema obi fair trial yema obi ho kwan say ono so en defend no ho onfa konfombra be defend no onfa adanse fombra en be defend na say court ma ho kwan na court enya abotra na court anya okeke en kyere say ubetum the court ni metwitwi form. It judge can say wo Apia Kubi woni chairman Wontumi ene saa eye the accused person ade a mo ye no emwaye saa nyama we nyina si wo court. Did you ever hear Apia Kubi come out to say court no me bibi na court na mfa me? Did you ever hear the Attorney General come to say this is what is happening in court? Apia Kubi abuse court no. The Attorney General did not have time for that. The Attorney General's job was to get a witness to cross-examine, was to get to the bottom. If there are there are things happening in court, obi abuse court now, it is not for the Attorney General to say. The Attorney General can raise objections and raise concerns in court, but the Attorney General, it is not his duty to make sure an accused lawyer follows rules and regulations or court proceedings, the regulations. It is the court. Until right now, the judge is talking. The judge is frustrated. The judge has seen Apia Kubi any chairman Wontumi no almost shut down on person mu court ni say delay case no until all the way from May they started delaying this case. Sa case where Attackea beso bi na nkeni say through June. So case we can say enter June. Apia Kubi ade oyeye because from day one not almost strategy. Delay the case. Now Judge Nisaka Saya or say the bedrock of criminal trials is fair hearing. Now at this juncture, Judge Nisaka Muntieno. This is all the way in May. The judge started getting frustrated with Chairman Wontumi Apia Kubi. All the way in May. Now Judge Nisaka say at this juncture, the court does not know whether or not the witness statement it has received in the name of Honorable Evans Atta Akyea is an addition or a substitution. At a point, now I say, Apia could be a cover statement for Fraba. I feel like court now confused. Evans, Honorable Evans Atta Akyea, now okay witnesses no. I feel by any dinim. I feel Saba court, Apia could be a cover, Sani Panano, assembly abase, Yanfa some way. Like I say, right now, I didn't know. List out the brain now kwe di wom afi pe quarter ni di nim yes our quarter was akofa statement bi aba say akwa ne statement ki judge say onim say or substitute akwa ne free case ni mo say odo bi be shebo right now the judge was confused say dey na apia ku bi ye no dey na chairman Wontumi ni apia ku bi I so money da ho na omaye say omo be book nim ti omo delay case no. This is May, and remember before May no my sanyoma we nyina bi ma judge na nka bibia. But you see, anytime they walk out of court, no man catch you. Case in there, Bibioboko, judge Nina, they do some time. They knew what they were doing from day one. Deliberate delaying of the case. I idea from day one. Now, now when you move forward, judge Nina say, I do not think this sort of practice assists the court in the smooth delivery of justice. TNA, judge Nina say, I do not think this sort of practice assist the court in the smooth delivery of justice. Or say the appear could be no, and the chairman want to moya or quarter. They be no makase, no delay court, no more. Or say sad day way are more no. Menya sure say mo pese court no e di ni juma say ne wo say di ni juma. I say mo ti mo pobi say court juma di no mo be say no. That is the statement of the judge. So the judge got an idea of what chairman Wontumi and the appear could be no more ye. Anything on one case no master no say me who say mo ye bibi say mo pese mo say case no mo pese mo delay case no unnecessarily mo pese mo shada na case we no eye tintia na nipa ehun say de ekọ judge no got frustrated. Remember Adewe has been going on for 5 months. The judge did not say anything, but it got to this point now. Feel appear could be too much, appear could be the other court no. And you see say judge bia wa body timu poso be di bone na otan chairman Wontumi nka case we can do me anka case we no anka say by a match na anka say judge no. But you see the judge and the court accommodated all these things. These are documents. These are some of the things they did. Now judge ni kore nim no, judge ni kore nim ka say me or say CMC, Case Management Conference, is to give direction and clarity to all parties in the matter and above all, avoid surprises. Or say, Sir CMC no mo a Case Management Conference no, ni nyina na say yebeko court ochna. Krata bi Attorney General, Edeba bebusa Chairman Wontumi and the other accused, or say Attorney General be judge in front of Apia could be enim. And as appear could be so, and a baby Sibu or better to a year Attorney General witness anwa. I was saying Krata or Busanina or the Bana Judge who send a bear in quarter or being of a Krata befra bontinamba Emma a Attorney General because appear could be Krata with the one fan chase will be some witness once them. Or say CMC and the Juma Diana no. Now then you quay CMC near Bana appear could be Ashada Danan once the own him say CMC. Now then Krata for fro, Nipa di for fro, statement for fro, or say sign your mana appear could be no washada. Now, Uku Edima, Judge Sakas, I was saying. So, when an accused person in the middle of a trial without leave of the court decided or decides at will to change witness in improper, and this is stated with caution to the accused person, the 1992 Constitution grants rights to all persons, especially in criminal trials. However, these rights should not be exercised in a manner that will degenerate into a pattern of abuse of the rules of court. And a court judge ne kachire eye de o kachire eye apia kubi ene chairman Wontumi say munim bibi de mo ye nyina sebio 1992 Constitution eka say nipa bia wo ho kwan say sebio yenka ne kashaboa enhye ne yem obetumi aka na adwene obetumi defend no ho obetumi afro obi amanaba abeya adansefo amano o say your constitution e kire say obia wo ho kwan say sebio obenya fair trial obetumi aka na adwene aka no kore ma yetie no o say na saa de na e wo ho constitution mu no saa eye tumi na constitution e de ama ye say Ghana fo ye betuma fa lawyer yɛbɛtumi akɔgyina court yɛbɛtumi aka sɛ oh sɛbi we deɛ menya hwee nipa we no wɔ hɔ bi we na madansefoɔ no ɔsɛ saa tumi na constitution ma Ghana ni bia no ɔsɛ ɔpɛ sɛ ɔma apia kubi ɛne Chairman Wontumi ho te aseɛ sɛ from nyɔma ɔma yɛ a ɔma hyɛ da ebu court nim tia ebu ɛyɛ deɛ constitution nim tia ɛma apia kubi continuously wahyɛ da ɛyɛ deɛ abuse court no see saa nyɔma no sɛbi ɔsɔ mo te aseɛ sɛ ɛyɛ adeɛ bi ɔma yɛ a ɔde n'ani ato fam ehu sɛ a follow pattern bi ɛyɛ adeɛ bi ade sɛ utumi tena ho sɛ wei ni adeɛ ade bi a ɔma fa mo adwene sɛ ɔmo bɛyɛ ɔte saa adeɛ na ɛyɛ deɛ ɔmo ɛyɛ a abɛyɛ ɔmo suban ɛne ɔmo su no sɛbi ɔno ɔyɛ judge no ohun ne pɛn fɛyi sɛ apia kubi ɛna ɔmo pɛ sɛ ɔbɛbu court no Chairman Wontumi a ɔyɛ accused person a wakɔfa apia kubi no ɔma bɔ ɔmo tiri mu pɔ sɛ court no ɔmo bɛbu court no nim tia ɔmo de court no nim twitwi fam ɔmo bɛsɛe asɛm no ɔmo bɛ slow asɛm no judge na asɛm ɔkan no ɔse saa nyɛma a mo yɛ yi ɛwɔ sɛ constitution no defend obiara but ate sɛ sɛ obiara hu mo tiri mu pɔ deɛ mo yɛ makama no atum ahwɛ waa wo apia kubi we panyini wo yɛ lawyer kyɛ but ate sɛ wahyɛ da sɛ wopɛ sɛ wobu court nim tia me judge ametie me nipa and also me tie obiara asɛm but ate sɛ from time ongoing time coming no why say adeɛ a wayɛ no na saa deɛ na woyɛ no ɛkyerɛ pɛfɛ sɛ wonim deɛ woyɛ why wadwene sɛ wobɛbu court no nim tia these are judge no words and yet these are not my words. Now judge Nicole did not say having cautioned accused persons. Now this is what the judge concluded on. Now court concluded on this having cautioned accused person, so it means the judge actually cautioned Apia Kubi, cautioned Chairman Wontumi, said you are abusing the court. Court na mama found with kakra se mo fandi mo dwuma no mo pese mo de eden ebu court denim tia enti for a judge to caution you it means the judge has had enough. For a judge to say dia mo ye no muntwa so mama mo time too much and from proceedings so you didn't see Apia Stadium Apia Kubi object to it. Apia Kubi never objected to the statement the judge made because no one said true and the judge did not say anything out of what is happening in court. Senka Apia Kubi the judge ne kano Sananka judge ni chatra Apia Kubi would have objected and say my lord this is not true, I never did this, I never did that, I will never. But you see because Apia Kubi knew what he was doing, because Apia Kubi don't him say or person delay case no or person abuse court no or person disrespect judge no or person judge ni bufu na judge ni bibi no. He knew what he was doing. Anything a judge no question or said the omo ye no a follow party be omunja no Apia Kubi didn't raise any objection. Now, having cautioned the accused persons, the court will exercise its discretion and adopt the witness and the witness statement as if the witness was listed as one of the witnesses and conduct CMC on same. Inti Apia Kubi omudi sa honorable Ada in statement in baya na at the end of the day na nkeni say Apia Kubi di fa back door di be wura court ni kaso ni bibi apart from all the things you have done sa inconsistencies abusing of the court still judge say meji ni statement no mesa aba CMC. So the judge was not even supposed to do it because one, the witness na Apia Kubi edeba no in the first place where you witness the film and in the second place the statement to that back no sebi na witness didn't sign here enya dem Paul Sanka call and so judge ni kaso ni bibi upon all the disrespect mo show me court ha upon all the disrespect that witnesses show me upon the things you are deliberately doing to delay the case still remember the chance come to CMC, that is case management conference, and come show me this new statement you have brought from nowhere and let the attorney general be here. I'll be here. I will look at it. I'll give you the opportunity. So you see, upon all the disrespect Apia Kubi show judge still the judge gave Apia Kubi that respect. Upon the basic deliberate mistakes he did, they're deliberate. They make it look like it's an oversight. It wasn't an oversight because judge not told Jimmy for. And Apia Kubi Debi Okacham say, or your experienced lawyer, he knows what he's doing. So the judge knew from day one what Apia Kubi was doing. But you know what? Aka judge Bianco about the timu pose or time Chairman Wontumi that day na kobe in the case no. Yeah, because those were not Apia Kubi and not Chairman Wontumi, not only witnesses biabim. But you saw what the judge did. The judge said, still, I will give you the opportunity. Memma mo chance. Somebody Evans Adai we come one. No problem. The statement from nowhere, we don't know where it's coming from. No, I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other, and come back again and put that person you want to put in the box for cross-examination. The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is you give people the benefit of the doubt. It does not make you weak. It's what it does is that it makes everybody understand out of your courtroom, because and you'll be in a raw courtroom. What it does is say that leniency, that room you give people you even think are abusing the court. When you do that, what happens is you make the case more transparent. You don't give people the room to go out there to insinuate, to create an impression, because you see, perception, when it's attached to a crime or a case in court, it basically dissolves the potency of the case. So I think what this judge was doing was that he didn't want to give anybody any room to say the accused person is being treated unfairly. Even though there were some things that this judge was supposed to stop, there were some things this judge was not supposed to entertain. A lot of abuses and disrespect to the judge herself or himself or the court, the judge was not even supposed to allow for some reason, because the judge wanted Ghanaians to understand that this case in court is not personal. She has no personal issues, or he has no personal issue with the Attorney General or even the accused, and that the judge's main focus was to make sure that this case, at the end of the day, whatever the accused has to present, they present it fully, and whatever the prosecution have to present, they present. So the judge was basically avoiding that perception that the accused person is being mistreated, the accused person is being gagged, the accused person's lawyer is not given the room. But you see, but the more lenient, the more diplomatically lenient the judge is, the more advantage Atta Akyea and Chairman Wontumi were taking of the court. So you see, now when you give people the room to protect themselves, you give them the room to basically be heard, they abuse it, they take advantage of it. So we are judge and Kaden and Kobe. But all these things happen in court. All these things happen in court. None of us was told about this. But these people are the same people. Atta Akyea. Right now, what is Atta Akyea doing? Atta Akyea is doing the same thing. But I'll go back to the ruling. About what happened in court. Nobody will accuse anyone of being hard on anyone. And it's all share, and I will study there. My dear, you can see clearly say from day one, Atta Akyea or Shadan or abuse case, or abuse court, and a with delay case, Now, should you see Judge Nikasawi, Atta Akyea Ekasaya, what did he say? I have a friend in Canada. He just texted me. He just told me say I should call the witch doctor Kuku Bonzam. Canada for any day. Xavier Kuku Bonzam. Xavier, I'll call you after the show. Now, Judge Nikasawi, Atta Akyea also responded to what the judge said. And then okay. Or say counsel for A1 and A3, that is Atta Akyea. Or say we have a witness statement of one Honorable Evans Adai. It was filed on the 28th of May 2026. I pray that the said witness statement be adopted by the court as a witness statement of the said Honorable Evans Adai. So formally, afei na all catch the judge and say, sir, witness na judge ni kwa CMC some time back and ani diwo ma Atta Akyea mu yifri mu no. Afei na Atta Akyea ka say ai, afei na the witness no edi ba ni statement nti yanko CMC ni yanko discuss biem. So you see, anytime I'm just say if Atta Akyea had an issue with the judge's pronouncement on the delay tactics, on the disrespect and abuse of court, and Atta Akyea raise an issue and say, Your Honor, or whatever, Your Lordship, in fact, what you are saying, without due respect, is not true. But you see, Atta Akyea didn't say anything, because what he has done, abuse the court, what if the judge did not have that patience, was not professional enough, has no interest in the Obika just focus on the case, and a judge in react here, press conference and Kapia could be abontre. Imagine the judge threw out this their witness statement out to say we have gone to CMC and that we came to court and you are giving us a different thing. Can him the Apia Kubi? Do you know the kind of impression Apia Kubi chairman Wontumi they would have come out to put? Can him the Kofi Benton Babakan Obontene? Can him the MPP dogs? Do you know how they were going to narrate that? But you see, the judge being an honest judge, not wanting to take sides, listening to everybody's piece, the judge still gave them the opportunity. And anything appear could because, Madam Judge, Mr. Judge, please, now we want to formally drop the witness statement. The court should adapt it. We should go and have CMC. Remember, Sankadia or Yen first, meaning the case has been dragged back again. This is all the way in May. They delayed the case for about 3 months, no reason. Now, so that is what happened in court. Makacha said this document, if you want to get it, go to the court. It's there. These are court documents.